Gregory Kutz is currently the Managing Director of GAO's Forensic Audits and Special Investigations Unit. Mr. Kutz has testified and written investigative reports about the federal government's handling of Hurricane Katrina and Rita, military pay problems at the Department of Defense, and smuggling of nuclear materials across our nation's borders, among other important issues.
Thank you for the opportunity to discuss the Department of Labor's investigations of wage and hour complaints. As you've heard, Labor has established a wage and hour division whose mission is to protect our nation's workforce. Today's testimony highlights 15 closed cases that show inadequate investigations of worker complaints. As you requested, we plan to continue our work in this area to determine whether these cases are indicative of systemic problems. The cases we investigated relate to low-wage workers. Their complaints related primarily to not being paid minimum wage or overtime, not receiving their final paycheck, or in some cases not being paid at all. These workers included cashiers, cooks, painters, plumbers, security guards, and truck drivers. These cases are from states across the country, including California, Florida, Maryland, Ohio, Texas, and Virginia. For these 15 cases, we found that Labor's investigations were inadequate. In some cases, very little effort was expended before a case was closed. In other cases, the case was closed because the 2-year statute of limitations was about to expire. Here are a few examples of what we found. First, a child labor complaint was closed because an employer could not be found. We easily identified this employer through a public records search and a telephone call. In another case, an employer admitted that wages were due, but told the investigator to call back later. After subsequent phone calls were not returned, the investigator closed the case. One case was assigned to an investigator 17 months after it was received. After the investigator held this case for 6 additional months, it was closed. And finally, one case was closed after an employer represented to an investigator that their revenue was below the $500,000 threshold where federal law applies. In a subsequent civil case, these representations were proven false, and the employer settled with these employees for an undisclosed amount. The most troubling cases to me are the ones where labor records indicate that wages were in fact due. Rather than pursue payment, Labor closed these cases and informed these individuals of their right to file a lawsuit. Examples of individuals informed of this right to file a lawsuit include a homeless person owed thousands of dollars, a gas station cashier owed a final paycheck, a garment worker whose employer was found by Labor to owe her and 23 other workers $60,000, and a painter whose employer refused to pay legally due wages because he and others were not U.S. citizens. The poster board in the picture on the monitor shows an example of one of these letters that Labor sent to one of our case study individuals. Note that in this case, you see the employer refused to pay back wages that were due. However, the next sentence says that no further action will be taken. Imagine how this individual felt after reading at the bottom of the letter that Labor is, and I quote, working to improve the lives of America's workers. This and other letters also inform individuals of their right, as I mentioned, to file a lawsuit. It's hard to believe there are a lot of attorneys looking to work low-dollar, minimum wage, and last paycheck cases. And even if there were, these people certainly couldn't afford to pay them. In conclusion, I can't tell you whether these cases are isolated or whether they're the tip of the iceberg. However, what is clear is that in several cases, employers got away with labor law violations with no consequences. If Labor's mission is truly to protect our nation's workforce, these cases indicate they have a ways to go. Mr. Chairman, that ends my statement. I look forward to your questions.